All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Welcome. This is the Arizona Court of Appeals, Division 1, cause number CV130397, Cost versus the AROC. For the party's information, these proceedings are being recorded both audioly and visually. Hopefully, if the equipment works, you'll be able to see yourselves on YouTube. As you approach the podium, please identify yourself and who you are representing. Each side will have 20 minutes to argue their case. Appellant, if you'll tell us whether you want to reserve time and how much time you would like to reserve, we will try not to horn in on your time. We have read the briefs, discussed the case in conference this morning, and reviewed relevant portions of the record. So with that in mind, you may begin.
May it please the Court, and good morning to the Court. I'm Craig Keller of Gusta Rosenfeld in Phoenix for the appellant Jacob Cost. Mr. Cost is in the courtroom this morning at counsel table. Your Honors, in this case, Jacob Cost disassociated himself from the contractor's license on July 26th of 2011. He used the Registrar of Contractors form. He followed the Registrar of Contractors instructions and Arizona law, and an amendment to the Articles of Incorporation were unnecessary. The ROC must be required to complete its ministerial act and reflect the disassociation in its license records as of July 26, 2011.
Did he really follow the form? The form had, if I remember right, 3 boxes. He checked all of them instead of 1. So can we really say he followed the form?
Yes, Your Honor, I think we can. In good faith and good conscience and using a belt and suspenders approach, Mr. Cost checked all of the boxes. To use a trite analogy, he said he wanted ice cream, he wanted bananas, and he wanted the banana split. And as best evidence of the fact that it was a proper completion of the form, Appendix 2 to our opening brief, the letter from Sparky Snyder in the Sholo office of the Registrar of Contractors, did not check the box that said the notice of disassociation form was completed in any way inaccurate or incomplete. He checked another box for what the registrar believed was an impropriety, and we argue was not. But in terms of what the trial court was looking at, he asked for A and not B, and then he asked for only B, and then he asked for all of the above. Now, was it an A+? Is it absolutely crystal clear? We think that...
You're asking us, or you asked the trial court to issue a writ of mandamus, which is directing the registrar to do something. And what you want them to do is to follow the instruction that Mr. Cost provided in the form, but there are different instructions. So how can a writ apply for that?
Because it's not discretionary to disassociate.
What is not discretionary?
The notation on the registrar's records, which it must keep as a matter of statutory law in the state, accurate and complete records of the licensees. And then it sends out a form, a notice of disassociation form, which it understands. And again, the best evidence of that is what Mr. Snyder said when he sent the infirmity letter, which we didn't get. But
wasn't the trial judge explicit, specific in its basis for its determination that in fact they couldn't simply undertake a ministerial act because they were given conflicting directions by the applicant?
But Judge Jones, that's exactly the position that the trial judge came to.
My point.
Without the parties arguing it. The Registrar of Contractors through the Attorney General's office did not argue that position. He never said it was incorrectly completed, inaccurately completed. Is it imperfect? Yes, but did the handler of that document, the Registrar of Contractors, particularly in this case Mr. Snyder, know what he was being asked to do? The form says notice of disassociation. and then it went through and said, I want out. I want to be disassociated completely
Seems to
from
me
this
that-
license.
I'm sorry to interrupt. It seems
Sure.
to me that in their reply below, the department discussed this, and certainly it appears it was discussed at the motion for new trial hearing, because the court explicitly comments on that in its minute entry. So you're not suggesting they didn't raise this argument or it's been waived?
I'm not suggesting that it wasn't discussed in terms of imperfection, in terms of whether or not the reader and the handler of the document understood exactly what it was because of the title of the document and what they did with it. I'm suggesting that, in fact, the registrar knew exactly what they were doing.
Okay, so if your client had gone into the Registrar of Contractors and had taken a form and said, I want to be off this thing, I want out of here, and he had just signed the bottom of it and handed it back and said, fill in whatever you want, but you now have a ministerial responsibility to accept this and act on it regardless of what I've said. You're saying that would be okay. Mandamus would require that he accept that. Because is there a difference between something that gives them no direction and something that gives them incredibly contradictory direction? Is there?
The failure to check any of the boxes may have been fatal. The actual checking of all of the boxes, particularly with the response of August 5th, 2011, some less than 2 weeks after the form was submitted, in which the registrar does not check the box that says the notice of disassociation has not been filled out completely or accurately, additional information is needed. I submit to the court that the reason they didn't check that box, and apparently, purportedly, this is somebody who does this every day to determine if there's some sort of infirmity with respect to the notice of disassociation, he didn't check that box because he wasn't confused. Mr. Cost came in, asked the counter personnel, how do I get off of this license? They give him the form, which is absolutely crystal clear. He fills it out, belt and suspenders approach, as I submit. The registrar takes it in, doesn't reject it there, takes it in, which their own form says, basically it is effective upon the filing. So they take the form in, then 2 weeks later or so they figure out that we need some more information about the disassociation relative to your position as officer and director of the corporation, and then they send the letter, as the court knows, they send the letter to the address of the licensee, who Mr. Cost shows up at the counter and says is defrauding the public. Even though there was an email address on the form itself, and the registrar didn't bother to send an email of that problem letter out to Mr. Cost. And we submit to you that that's no notice at all, and that in fact they don't have the right to reject that form by requiring something more than what's required in the statute for a corporate officer to resign from the corporation, which is absolutely clear. All you need to do under ARS 10-843 is to provide notice to the corporation of the resignation. And the facts in this case suggest, in an undisputed manner, that that's what happened. And so basically, he had resigned, he had followed his statutory right, and it's interesting, because of the ROC's forms in this case, they treat the disassociation, the act of disassociating, as a fait accompli. So just like on your driver's license, when you have to go in, I believe it's 15 days after you move and give notice to the department that you've moved, the registrar treats it the same and says you have to provide the notice within 15 days. Notice of what? Notice of disassociation, which has already occurred. And so Mr. Cost goes in, disassociates himself on their form, asks if there's anything else I can do. I want out of this. This company is defrauding the public. And the registrar says nothing, takes the form, and then notifies the company at the corporate address where Mr. Cost is claiming they're defrauding the public. Makes absolutely no sense whatsoever.
Counsel, if the filing, if the notice of disassociation, this is based on what you said just a minute ago, if the notice of disassociation is effective upon filing, and you filed it, then why do you need mandamus
Because, Your Honor, they will not note in their records, which they have a statutory right to do, that as of the date of filing, and this is uncontroverted, July 26th of 2011, they will not note that as of that date, Mr. Cost was disassociated from Thinker Development.
So, and I don't mean to in any fashion belittle your position. The reality as we sit here today then is that as long as you have your filed notice, you have the ability to say, no, it's effective upon filing and we can show you the date that we filed the association, regardless of what they do thereafter, correct?
Appendix number 1 to our brief shows exactly that.
My point.
In their own words.
It's effective upon filing.
Yes.
And it was filed on that date, and you can show it was filed on that date. My question again, what does mandamus obtain for you?
Mandamus attains the change in the records at the Registrar of Contractors that goes from this date in November of 2012 back to the date even their own form, which they prepared, says is effective on the date received. And then they have a stamp at the bottom of appendix number 1 that shows it was received on July 26, 2011.
I think what Judge Jones is asking you is, it sounds like, I mean, the reason you're doing this is to have a defense, presumably, to something that may happen down the road. And I think what Judge Jones is perhaps suggesting to you is that you've got that defense one way or the other as to whether or not there is an official entry in some registrar page, when your argument is the mere filing and stamping of this document on July 26th is sufficient for you to exercise it, to raise that defense.
And it may be, Judge. It may be that, and certainly would be our position that we do have that defense, but it's also the legal requirement of the Registrar of Contractors to keep accurate records under the statute, and they're not doing that. And they're claiming that it's discretionary. And our position, as you know, is that it's not discretionary. It's not like the statute gave them two alternatives, and you're not going to substitute your wisdom for the agency's wisdom on how they allocate their resources. This is not that case. This is a ministerial act where their records must indicate the date of the disassociation, which we also believe will have the practical effect that when persons looking in the public records are looking for persons against whom to make claims, they will see that the disassociation is not November of 2012, but in fact is, as the registrar's form says, July 26th of 2011. And so the trial court, we believe, found facts and made factual inferences in favor of the Registrar of Contractors when just the opposite should have been true. If there were issues, we don't think there were issues. The document was accepted, it was received, it just wasn't processed. And so if you find that there are issues, then those fact issues preclude the court denying our complaint or dismissing our complaint on the motion to dismiss. Those fact issues in a well-pled complaint are taken as true, as you know, or inference resolved in our favor, and therefore the complaint should have remained. They then said that we didn't do certain things that we should have done, and yet they don't tell us what those things are. That's where we claim that they came up with this, I don't know if it's an internal regulation, a policy or procedure, a practice. We've never been told that proof of the resignation or amendment to the Articles of Incorporation need to be filed with the Corporation Commission and proof submitted to the registrar. This honorable court will not find anything in the statutes, anything in the regulations that require that, and yet that was the basis for the rejection. And then once...
You are aware that they're requiring that on the form today?
Yes, I am aware that they've changed their forms to address this specific problem, interestingly, without telling us, without telling the trial court, without providing any notice of it, which is absolutely consistent with the Attorney General and the registrar's practice in this case of hiding the P. And we suggest to you that that is not the sort of conduct that we would expect from the Attorney General's office or expect from the Registrar of Contractors. And so when our client says to us, who do I trust in this case? I've told them that that is not my signature on the corporate document and that I did not backdate that document. We provide that information to the Attorney General, and the Attorney General nevertheless continues in this case to argue that Mr. Cost has unclean hands, that he has defrauded everyone, and led the trial court down a path from which it could not recover. The trial court then made these findings, which it is not authorized to do, when reviewing a motion to dismiss, and here's where we are. So I'd like to reserve at least 5 minutes of my time for rebuttal, but don't make short shrift of the argument of substantial compliance, because it sure seems to us by analogy that if you're going to allow a contractor who is unlicensed but took conscientious steps to get a license to be paid under one of the strictest licensing statutes in the nation, you're going to allow that contractor to be paid because he substantially complied. In this case, substantial compliance ought to be enough to allow the disassociation to take place on the exact date that the registrar says in its forms it should happen. This standing argument, finally, and I will reserve the rest of my time, this also shows the deceit and lies of the Attorney General and the Registrar of Contractors in this case. They knew when they filed, or should have known when they filed the motion to dismiss, that there were pending recovery fund claims. And yet they advised the trial court that there were no pending claims. And you know from the supplemental notice, statement of facts that they filed in this case, that they've now backed off that position. And they backed off that position because if you look at the public records, which we cited, you will see that there were recovery fund claims pending. And so when they argued to the court disingenuously that Mr. Cost does not have any skin in the game and therefore he doesn't have standing, yes, he has skin in the game and yes, he has standing. Those recovery fund claims matured when payment was made. They were pending at the time of the motion to dismiss. The trial court was unaware of that. We were unaware of that. And again, the trial court came to the wrong conclusion by finding facts that were inconsistent with what was pled in this matter.
Were those claims pending at the time as of July of 2011?
Yes, they were pending. I believe they were, Your Honor. Yeah, there's more than 27 registrar of contractor complaints and recovery fund claims, which all matured at different times. And we've made, as if we've noted in our briefs, we've made 2 different public records requests, and we've gotten some incredible responses in that, and not accurate and thorough, frankly.
Oh.
So we don't know, and that's the reason why, in this case, discovery should have gone forward to find out all of those specifics, because the claim that was made by Jacob Cost was valid, it touched the basis, and mandamus is appropriate, and I'll reserve the rest of my time.
Good morning. Michael Rain with the Attorney General's Office, here on behalf of the Arizona Registrar of Contractors, and may it please the Court. In response to the ROC's motion to dismiss, Mr. Coase stated, and I'm quoting, that a material fact dispute exists as to whether Coast knew he was listed as a corporate officer and whether he followed proper procedures to be removed from Thinker's license. You also just heard argument about the need for discovery, the fact that the trial court improperly made conclusions of fact when all these things should have been tested in some sort of hearing on the merits, I presume. And that tells you really everything you need to know why mandamus is inappropriate in this case. That, what is being represented there, is a garden variety administrative review action. If the ROC ever took action against Mr. Coast as arising out of those recovery fund claims, he would have the right to an administrative hearing before the Office of Administrative Hearings. I handled one of these hearings last week, a hearing under 1139, where the material questions were, when were you off or on the license, as the case may be, and when did the causes of action accrue that gave rise to the recovery fund payments? That has never occurred. The ROC has never proceeded against Mr. Coast under any theory of when he was on or off the license, and that kind of gives rise to the standing and the rightness issues that have been discussed in the briefs.
Do you intend to go after Mr. Cost for
What?
some of these recovery funds? Do you intend, does the ROC intend to go after Mr. Cost for some of these funds?
I don't know the answer to that question, and I don't think that the ROC should be required to telegraph what it intends to do in the future in administering its own statutes. All I can tell you with certainty today is that they have not gone after him at all. When they do, he will have that right.
Are the parties in agreement that the notice of disassociation was effective upon its filing?
Absolutely not. The notice of disassociation says something completely different. What it says is it's effective upon receipt, and that document was rejected. It wasn't received. It came in, it was faulty, and it was rejected.
So
It can't, I'm sorry, go ahead.
I'm sorry. So as counsel said that they believe, and that Judge Winthrop was exactly right as to the reasoning for my questioning, to the extent that they say that they do have a defense because they can show that in fact it was filed and with the filing it was effective, you're saying was never filed, it's not about filing, it's about receipt, we never received it, we immediately returned it.
Essentially, and just to pick up on the logic that I thought I heard there too, there has to be more than just the filing of a form, just as though there has to be more than just the filing of an application for a license.
What?
Proof that the claims on that piece of paper are accurate. Anyone can go file a notice of disassociation if the ROC has no right or ability to say, well, let's make sure that's true.
Okay.
Then-
And counsel also addressed my question about the fact that he understood that the form has now been amended. The form now includes a requirement that the Articles of Incorporation, the amendment to the Articles of Incorporation be submitted with the filing, correct?
I believe that's true.
Hence, my next question, which is that then a violation of statute? Because counsel said there's no authority under the statute to require that.
I don't think that that's a question that gets answered in mandamus. I think that's a question that gets answered in a judicial review action under the Administrative Review Act. The ROC would go to that 1139 hearing and it would argue, we interpret our statutes to require you to give us more than just the form, especially if we ask for it. And he would say, no, that's an improper interpretation of the statute. And that would get resolved, and then there'd be a right for appellate review at the Superior Court through the Rules of Procedure for Judicial Review of Administrative Actions. Then it could even come to this court for a fresh review. Those all get resolved in the normal course in such a garden variety administrative action as this is. There's no reason this court should weigh into those questions which have never been answered. There's no statute which tells you the answer to that one way or the other.
So I'm sorry to interrupt, but you're basically suggesting that Mr. Cost has to wait until, just to see whether and if the Registrar of Contractors brings some sort of action against him before he can raise this issue.
I think that's exactly right, when he's seeking mandamus. Now, perhaps there could have been some sort of declaratory judgment action filed. That's not what's before you, and I don't think you could construe this to be that. But in the Sears v. Hole case that's cited, in the Yes to Prop 200 case that the Mr. Coast cites, both cases say very specifically, mandamus is not an avenue to get these contested issues resolved. It's not a substitute. The Sears court says that if you're virtually any citizen could challenge any action of any public officer under the mandamus statute by claiming that they failed to uphold or fulfill state law as interpreted by that party. That's not what mandamus is about. Mandamus is about there is a specific legal requirement on an admitted state of facts, not a contested state of facts like we have here, and you have to do what the law tells you to do. You don't have that in front of you. You have no statute or case or any authority which tells you not only that the ROC can't have this additional requirement of some sort of corresponding evidence at the Arizona Corporation Commission, but that it needs to relate its notice back to the original date of filing. There's just no authority for that.
So what you're saying is that under this complaint, the plaintiff's not entitled as a matter of law to the remedy he seeks, but that under a different cause of action, he may be entitled to a remedy of sorts.
Absolutely, and I think that the Superior Court said almost that exact thing when it said that it didn't need to accept Mr. Coast's conclusion that whatever the ROC's records say as far as when he's disassociated is the truth of when he's disassociated. I think you have two questions. You have a notice of disassociation and disassociation in fact. And I think it's a plausible argument to say, hey, if I'm going to be held responsible for someone else's conduct because I'm associated with that entity, if I really wasn't, and I had nothing to do with these underlying causes of action, I think it's a fair argument to make to say that I shouldn't face liability. I don't know that it's the correct argument because the ROC does have statutes which require parties to give notice, and I would argue that it should be able to require its licensees to give affirmative notice. We heard the argument here that says, well, under corporate law, you're off whenever you give notice to the company. But how does that help the ROC know who's on what license? How does it help the public know who's on what license? As long as you're off in secret, you're off. And whenever the ROC chooses to come after you, all you have to do is point to that. I mean, I don't think that it's the correct argument, but I think that that's the argument that I'm sure they will raise if the ROC ever chooses to go after them, which hasn't occurred yet. But when it does, there will be a hearing, there will be administrative review. On the contrary, if mandamus was to issue, there will never be a hearing. There shouldn't be a hearing. I mean, this court or the Superior Court certainly shouldn't take discovery and hear testimony and accept evidence in an action for mandamus. It's completely contrary to what a mandamus action is all about. But if it's granted, that'll never happen. And the ROC will be stuck with whatever Mr. Coast alleged.
Can I ask just another question? And that is, your position is this document was handed to someone at the ROC office, but that it was not filed, and this remedial notice then went out to the licensee. Is the document that Mr. Coast submitted, is that in fact included within the registrar's record?
I'm not sure I understand the question. The notice itself?
Yes, the notice itself. Is it retained in the registrar of contractors' records?
Yes. Yes, it is.
It's just not noted on
No.
a public website?
Yeah, I think what's noted on the public website, and I'm sure counsel will know this from looking at the public record. I'm pretty sure what's noted on the ROC's record is when they actually disassociated them in their records, which was sometime in, I think, February. And that's subject to a dispute. It is. I'm not going to tell you that when he's off. Is it February when the ROC finally did it? Is it, or excuse me, I think it was November when the ROC finally did it. Is it February when his prior counsel wrote to the ROC and tried to clarify it? Is it October when he finally amended the Articles of Incorporation? Or is it July when he submitted the form for the first place? Those are questions that get resolved in the administrative review action, and they shouldn't get resolved in an action for mandamus. And part of the thing is twofold, because there's nothing in the statutes or the laws that require the ROC to retroactively date anything, or to even, there's no statute or case that even says the ROC needs to disassociate anyone. The only statute that exists says that someone needs to notify the ROC of disassociation. But impliedly, I assume that there's some remedy or right that would allow someone to remove themselves and not face liability in perpetuity just because of an association in the past. But as I keep saying, those questions get resolved in the appropriate forum when the action arises, because the ROC takes action against Mr. Coast. Under the Administrative Review Act, he can review the interpretations of the law. He can test whether there's substantial evidence to support the ROC's decision. He can determine whether it was an arbitrary or capricious decision.
But you're also, I don't know if you're conceding this or not, that he could perhaps affirmatively raise these issues in a declaratory judgment action.
I presume as much. I haven't done any research on that. What I do know for certain is not in a mandamus action. I understand that Mr. Coast wouldn't want this Damocles sword hanging over his head that, hey, one day the ROC may come after me, and at that point I'm going to have a big trouble, and I'm going to have to prove all these things. I get the fear. It might have not merited the effort that has been put into this case through mandamus coming all the way to this court. It seems like it's a self-fulfilling prophecy. He's gone through all these layers of litigation to avoid a harm that might come in the future. So I understand why he'd want that issue clarified, but it's just not mandamus. It's just not the way that it does get clarified. And the other reason is, and the case repeatedly say it, is if there's an adequate remedy at law to have these issues resolved, and there is, and it's the Administrative Review Act. I do want to note, we heard some discussion about the form being accurate, and I think this court can look at the form and see that it asked for 3 inconsistent things. It didn't ask for bananas and ice cream and a banana split. It said, I only want bananas, I only want ice cream, and I want a banana split. And it just doesn't give the ROC anything it can say, okay, we'll do that. We'll do exactly what you said. The ROC would have had to make a leap and say, I'm going to assume this is what you mean. There's no requirement that they do that. Instead, what they did is they rejected the form and they asked for some clarification.
In fact, if they had assumed or presumed one element, they would have assumed that the information they'd been given in regard to the other elements was in fact not true, correct? You can't have the one and not deny the other, or excuse me, Mr. Coast, you've been a distraction to me throughout, and this isn't typical, but
I'm sorry, you just nailed the nail in the head. I apologize.
stop. Counsel, and I've lost my place. Do you understand what I'm asking?
I do, and I think that's what the Superior Court picked up on, is we're looking for some reason to tell the ROC, you must do this. And if you look at that form, how can anyone say you must do what the form says when it's an impossibility? You cannot do it. A few other points that I wanted to address that came up on argument. Counsel says Sparky Snyder, this individual at the ROC who accepted the form or rejected it, as the case may be, he knew, quote, he knew what was meant. How do we know what Sparky Snyder meant? Has there been a hearing? Of course not. This is an action for mandamus. So we can't sit here and talk about what Sparky knew, what the ROC should have known, why the ROC did anything it did when there's been no testimony of any kind about that. So the idea that the Superior Court construed facts and what I hear is an argument that, well, you know, they kind of treat it as a summary judgment motion or something and they resolved facts. I don't think that's what the Superior Court did. I think what the Superior Court said is, I don't see anything here that requires the ROC to do something. You've not given me any statute or any evidence, you've not alleged that says you must act. The Superior Court was allowed to look at the documents that were attached to the complaint, which included the notice of disassociation. That doesn't take it out of a motion to dismiss. And it wasn't required to treat as true legal conclusions, such as that Mr. Coast should have been off the license as of a given date, or that the ROC cannot require this additional step of something being filed with the Corporation Commission. Those are legal conclusions, and the Superior Court wasn't required to accept those as true. I do think that a lot of times you might worry, you know, we've come this far in the Court of Appeals, and you want to afford some sort of relief. And I just want to return back to the point I made earlier, which is there is nothing that denying mandamus will not eliminate Mr. Coast's ability to have all these issues resolved in an appropriate forum. But if you grant mandamus, you will, or if the Superior Court does on remand, it will eliminate the ability of the ROC to judge whether or not what Mr. Coast has said is true in the first instance, to make that call, as it's typically allowed to do in interpreting its statutes, and it'll eliminate the ability of any judicial review of that. So it's unfortunate that we've come this far on a liability that may never come to pass, all the time and money that's been spent. But the silver lining is when Mr. Coast, if he loses in this appeal, he's really no worse off than he was the day he filed it. He still can wait and see if the ROC takes action, and if it does, he'll have all these questions raised. There'll be discovery if they're so inclined. There will be a hearing on the merits with testimony and witnesses, exhibits, and so forth. And if he disagrees with the way the ROC interprets its statutes or the facts as found by the ROC, then a court will review that, and it will make that determination. But no court has done that before, and for this court to do it or for the Superior Court to do it, it will necessarily have to resolve these facts. It'll have to jump into those issues of statutory interpretation.
Mr. Rain,
yeah.
I want to go back to something that you said. You said the trial court found that the form was completed, didn't know what to do, the ROC wouldn't have known what to do. But Mr. Cost makes the argument that, well, that wasn't the reason that the ROC gave for the rejection of the notice of dissociation. they said we needed to provide proof of the change in the Articles of Incorporation. So Mr. Cost argues that the trial court improperly found facts that the ROC didn't argue didn't find when it denied his notice of dissociation. Can you respond to that argument?
I think, well, I don't remember seeing any law cited for the fact that a superior court being asked to issue an extraordinary writ of mandamus or to exercise equitable powers or what have you can't look at the complaint and decide on its own sua sponte whether it thinks its jurisdiction should be deployed. I don't believe that that's the case as a gut feeling. I didn't research this independently, but I don't think that there was anything improper in the Superior Court looking at the complaint and determining whether it stated a cause of action, even if it was on a basis that the ROC didn't assert. The fact that the ROC asserted in its form that it was because he hadn't been removed off the Corporation Commission, not that the form was completed incorrectly, would be a good argument to raise when the ROC, if that case ever occurred, asserted in an administrative action that that was the reason why it did what it did. But I don't think it really has a whole lot of relevance where we are here today. Indeed, this court can affirm the Superior Court if it was correct for any reason. So I think that the idea that just because that wasn't a specific issue raised by the ROC at the administrative level, that it couldn't be a reason for the Superior Court to deny the relief requested of it. I just don't think that there's authority for that position, and I think courts would like to be able to exercise their own judgment when they are asked to exercise this sort of extraordinary power of a writ of mandamus. Unless you have questions for me, well, let me before I give up the stage here, there was the brief mention of substantial compliance. And I did cite in the briefing the Adams versus Boleyn case that involved substantial compliance and an action for mandamus. And in short, that case involved the determination that election laws had been substantially complied with, and so the person was entitled to be on a ballot. But what the court found is that they submitted it prematurely. And they said mandamus doesn't lie for us to retroactively accept it or to hold it and accept your application later. I mean, so even if he substantially complied by filling out the form, which I don't understand how you can, when there's one form to fill out and you fill it out wrong, I don't think it's substantial compliance. But that still doesn't get to the actual relief he wants, which is to be retroactively disassociated to the date he filled the form out. And the Adams versus Boleyn case, I think, is a good example of that, where you might be entitled to be off the license, but not as of that date when you submitted the form incorrectly. There's no requirement at mandamus that makes us date it back. Unless there's any questions, I would conclude my argument.
Okay,
Thank
thank
you.
you very much, Councilor.
My interpretation of the Attorney General's argument and the Registrar of Contractors is that you should wait until the right time to do the right thing. I think you can see in the case before you that Mr. Cost did not wait to do what he thought was the right thing. Maybe the Registrar and the Attorney General will wait some period of time until ripeness occurs and until there's enough of a damage claim on 27 plus complaints filed to do the right thing. But we did the right thing as we understood our obligation under the statute, and that was to give notice of the disassociation and to bring to the registrar's attention the fact that the company on which we were a qualifying party of the license was out defrauding the public so that the registrar could take some action. We thought that was the right thing to do. Instead of allow, $57,000 plus in damages to members of the public who contracted for roofing work to get done, paid their insurance checks, and then never got the roofing work done. We thought that was the right thing to do.
So what about his argument that it's not ripe yet, that we shouldn't decide this because Mr. Cost will have an opportunity to have all these issues heard and have judicial review of these, if and when this ever comes up?
Your Honor, that might be right with regard to the specific recovery fund claims. It is not correct with respect to the accurate date for disassociation on this license. And what the state doesn't seem to address at all is 32-1104A2, which requires the registrar to maintain a complete indexed record of all licensees. And then we heard no argument at all, no contradiction of the holding in the Sears v. Hull case, where simply stated, without respect to all this other fogginess, simply stated, the court says, mandamus lies if a public officer is required to perform the act. We filled out their form. The guy who was handling the form wasn't confused. He processed the form. I don't know what rules and regulations they're operating under, but the form is devoid of any requirement for us to do anything else. There's no statute requiring us to do anything else. There's no regulation requiring Mr. Cost to have done anything else. Where's the logic in now taking the state's scope and focusing on Mr. Cost on everything he presumably did wrong, when really the view is this complaint good enough? Did it touch the basis to establish a mandamus action, which clearly lies under statute and case law? And so Sparky Snyder wasn't confused. These are arguments that are raised by the lawyers after the fact in trying to justify why the Registrar of Contractors doesn't respond to inquiries from two different lawyers, doesn't note the proper date of disassociation, argues that there are other requirements that none of us can find anywhere that we could act in accordance with on a going forward basis. Then they change their form and say, wait till it's ripe. Do the right thing at some later point in time. We want the registrar to do the right thing now, which it is legally required to do, and that is note the records on the date appendix number 1 was received.
Thank you.
Thank you.
Out of time, counsel. Thank you very much, both of you, for your arguments. Very well done. We will take this matter under advisement, issue a ruling in due course, and we are adjourned.